Good afternoon, my lords. My lords, I was just turning to George Cohen, still addressing the point that an assured can give a precautionary NOA on the basis of guess or conjecture, and that will be valid if it can subsequently be shown to be justified by the facts existing at the time. My lords, that is the decision in the George Cohen case that we refer to in our skeleton. I'm not going to turn up the case, but I will give you the reference. It's volume 1, tab 19, and pages 691 to 692 of the bundle. And Mr. Justice Roche held that the NOAs in that case were valid, although they were given, in his words, on the basis of business instinct or guess or conjecture, before there was any reliable information of the loss. And he held those NOAs were both in time and valid. And my lords, I've referred occasionally to practical advice given in the textbooks and by average adjusters. I showed you the reference to Professor Rose's book on this point, and we also refer in paragraph 67.1 of our written case to an address by the chairman of average adjusters. I'm not going to turn that up, but we've set out the relevant passage in a footnote to 67.1 of our written case. My lords, there is nothing in any suggestion that it is somehow unfair to an assured if he has to give NOA immediately in order to be able to rank costs towards a CTL claim. An assured will or should know at the outset whether it is in his commercial interests to claim for a CTL if he can. And certainly, in a case where there is a valued policy, it will almost always be in the interests of the assured to abandon. And that's the reference in footnote 3 of our skeleton that I have given. My lords, the same point is repeated, and again, I don't turn it up, but Mr. Justice Blackburn in Kemp and Halliday, the reference is volume 1, tab 8, page 438. And Mr. Justice Blackburn says, quotes, in general, it is for the benefit of the assured to treat a loss as total. And this is peculiarly the case where the policy is a valued one. So making the same point as Lord Ellenborough in Baybridge and Nielsen. My lords, it also does not follow from our case that an assured cannot, if he wishes, if he chooses, decide to wait before tendering NOA. He has a reasonable time before he has to tender NOA, and if he wants to wait, he can. But the consequence of doing so is that he cannot rank any costs incurred prior to NOA in a CTL calculation. That's the only consequence.
What's the benefit of waiting?
Well, if, and I don't accept that this would be the case, but if he wants to consider his commercial interests, I don't accept that he would need to do that. But if for some reason it was suggested that he did, then he can wait if he wants to. If he wants to maximise his chances of claiming a CTL, he should tender NOA immediately and then try to justify it.
And on your submission, one could have a whole series of NOAs given at periodic intervals.
Potentially, my lord, yes. And that, as I say, that is exactly what Lord Justice Donaldson contemplates in his speech. But and I mean, the other point, my lords, it said, the question was asked, well, what happens if the assured has to incur some costs at an early stage? And the answer to that is, well, if he wants to rank them to a CTL, he should tender NOA immediately. And if he wants to keep his options open, he can still most likely recover in respect of those costs as sue and labour expenses. He just can't rank them to a CTL calculation. And as your lordships will appreciate, the sue and labour expenses are recoverable separately and in addition to a CTL claim. So that's what the end result in this case, as per the judge's judgment, is. There's a CTL claim for the full insured value and the increased value, but the insured can recover additionally for, on top of the CTL sum, for sue and labour expenses incurred prior to notice of abandonment. And my lords, when we were looking at the points about the overall justice of the situation, just note that the position in America under the American policy wording is that you cannot, this is by express provision, but we would submit that this reflects the reasonable commercial balance between the insured and the insured and the insurers. The position under the American policy wording is that you cannot both rank pre-NOA CTL costs towards your CTL calculation and also claim them additionally and separately as sue and labour. But that is the effect of what the respondents in this appeal say English law is, that they can do that.
So double counting, you would say?
Well, we've phrased it double counting. They dispute that, but it's claiming additionally on top of the CTL figure.
This is the which American policy is that? Just to make sure I understand.
It's their institute time clause, isn't it?
Yes. It's their institute time clauses, and it has a specific provision that you cannot do both. You can rank them if you want. You can rank pre-NOA costs if you want, but you can't then also claim them additionally as sue and labour expenses. My lords, just picking up on paragraph 68 of our written case, the Court of Appeal relied upon the Petrus M. Nomikos case, but we submit that doesn't count against us in any way. We accept that a vessel may be a CTL in fact at a particular point in time, independently of the right to abandon.
Independently of the notice to abandon.
Can't
abandon if it's not a CTL.
Of the notice to abandon. So we accept that you can have a CTL. It's the point I made. CTL is time specific in our submission. But the relevant point is that the CTL or no question has to be asked at a specific time. And the fact that the vessel was historically a CTL, in fact, is neither here nor there. You have to ask the CTL question at the time of the NOA, and it's a forward-looking question. Now, in Petros M. Nomikos, the claim was under a freight policy. So NOA was not required in any way to make the claim for CTL. And the House of Lords proceeded in those circumstances on the basis that it was simply necessary to show that the vessel was a CTL at some time during the course of the relevant charter party. Because once it was established that the vessel was a CTL during the course of the charter party, then the freight was lost. And, my lords, can we just pick up here paragraph 37 of my learned friend's written case? So this is tab 6, page 109. They cite the Nomikos case for the proposition that whether a vessel is a CTL is a question of objective fact, but they say one that necessarily relates back to the date of the casualty. Now, my lords, I'm not going to take you to the case to prove a negative, but it doesn't provide any support whatsoever for that proposition, the relating back to the date of the casualty proposition. And the respondents and the judge and the Court of Appeal were simply wrong to suggest otherwise. And my lords, the point is obviously wrong as a matter of principle, not only because of the prudent uninsured forward-looking test, but because the vessel may not be a CTL at the date of the casualty, but only become a CTL subsequently, for the reasons that I have addressed. And, my lords, this is the fundamental flaw, really, in the respondent's case and the judgments below. If one looks at paragraph 58 of the respondent's written case, it is plain as day that what the respondents are contending for is an approach which requires the assessment of the CTL at the time of the casualty. And that is just not supported by the Marine Insurance Act or any law. And it is obviously directly contrary to what Carver said was the law in his presentation.
Is that what they are necessarily suggesting? What they are suggesting, I thought, was that you essentially look at the consequences of the casualty. When you give notice.
My lords, their words are that the test looks forward from the date of the casualty, not from the date of the NOA, and they say...
Exactly, so you start with the casualty, you look for the consequences of the casualty, which may not all be apparent at the time of the casualty. Determine whether there has been a CTL at the time that you give notice. Ask yourself the question, but what is the question? The question is, what has happened since and as a result of this casualty?
Well, that may possibly be the way they develop their case, my lord, but that is not the way they put it in their written case. Their written case is on the forward-looking nature of the test. It's paragraph 58. They say the test looks forward from the date of the casualty, and they say that the assessment of the CTL dates back to the date of the casualty. So, in effect, they are saying, and this is certainly the effect of their submission, that you assess the CTL or no question at the date of the casualty.
Well, if that's what they're saying, then I see the force of your criticism of it. If not.
It may become clear this afternoon, my lord. That's certainly how I read their paragraph 58, but they may disagree. As to paragraph 38 of their written case, my lord, they say colourfully as CTL, in fact, cannot unbecome a CTL by reason of a lapse of time. And my lord, that is just obviously wrong. Look even at the capture and recapture cases, and we say that the same principle applies in the damage cases, as made clear, very clear, in Humphreys and Dickey and Hall and Heyman and the Medina Princess. My lords, in paragraph 39C of the respondent's written case, they say that our submission gives rise to a, quotes, nasty trap, close quotes, for the owners. But that is just not right. As I have said, the insured can serve an NOA right at the outset if it wants to maximise its chances of claiming for a CTL. and he can serve multiple NOAs if he wishes to. And my lords, the reference to Lord Justice Donaldson's speech on that is volume 2, tab 65, pages 1429 to 1430, under the heading Successive Notices of Abandonment. My lords, the respondents in paragraph 39D also make the irrevocable offer point, and I've dealt with that. And in paragraph 70, my lords, they suggest that the fact that the vessel must be a CTL at the date of the NOA is simply an invocation of the principle of redemption of loss. But, my lords, there is no authority that supports that. It seems to be premised on the idea that the CTL question is necessarily to be asked at an earlier point in time, prior to the NOA. They don't specify when, but apparently only at the date of the casualty. And the submission then requires one to say, you ask at the date of the NOA, and if necessary at the date of the claim form, whether that prior loss has been reduced or made good. So the premise of the assumption is that the CTL question has to be asked and answered at some time prior to the NOA. And we submit that that is convoluted, wrong, and not supported by any of the cases or the text. My lords, a point on paragraph 73 of their written case. They say that the date of the NOA and the date of the claim form must be different dates. But, my lords, that is not right. And can I just refer you there to Lord Justice Donaldson's speech, again, volume 2, tab 65, pages 1428 to 1430. And what Lord Justice Donaldson states, and this is correct, is that the obvious answer is to issue the writ as soon as it is clear that the notice of abandonment is declined. And of course, in most cases, my lords, the parties can enter into and do enter into a writ agreement so that the proceedings are deemed to be commenced at the date of the NOA. My lords, can I just deal very briefly with some of the authorities that the respondents say support their position. The first case that they refer to is Holdsworth and Wise, and that's tab 3 of the authorities bundle, volume 1. And my lords, this is not a case about CTL on the, this is important, this is not a case about CTL on the basis that the cost of repair exceeded the value of the ship. If one picks up the judgment of paragraph 3 at page 397, in the judgment of Mr. Justice Bailey, about 6 lines down in that judgment, my lords, you see the sentence, thus capture or the necessary desertion of the ship constitutes a total loss.
Sorry, where are you reading from? 397?
397, my lords. In the judgment of Mr. Justice Bailey,
Oh,
just halfway down the page, about 6 or 7 lines down in that. Thus capture or the necessary desertion of the ship constitutes a total loss. And what happened in this case was that the ship was captured and the crew abandoned her. So that was the total loss. And the test that the judge applies is whether that loss was reduced to a partial loss. And he said it could only be reduced to a partial loss if the assured could be expected reasonably to take possession. And one sees that if you turn over to page 398. So that total loss that occurred at the time of capture and necessary detention, the judge says did not cease to be a total loss. And he says the ship must be in esse in the kingdom in such circumstances that if they please, they may have possession and may reasonably be expected to take it.
So what happened in this case?
The ship was captured, my lord, and then subsequently returned.
It wasn't a case of capture.
No, it was a case of being...
Desertion.
The ship was
Desertion.
abandoned
A case of
by the crew.
desertion, salvage cost, and then repair cost. That's
Sorry.
what it was about.
It was
And then recovered in a place where it was impractical for the owners to take possession of her.
It was deserted.
Because they'd have to send a crew out.
Another crew came and took it and brought it back to a particular place. And
And then they claimed salvage,
Yeah.
which was at a price greater than the
Yeah.
value.
Yeah, that's the point. So the test that being applied was had the total loss by desertion ceased? No, because the assured could not reasonably be expected to take back the vessel. So the case doesn't help at all. And my lords, this is one of the main cases that is supported in Arnold in support of the proposition for which the respondents contend. It simply doesn't cover the issue at all. Rosetto and Gurney is the other main case, my lords, and that is tab 6 of the authorities bundle, and this provides no more assistance at all. It's a case concerned with cargo insurance, and the test that is applied, and my lords can see this if you turn to page 416 of the bundle in tab 6.
Sorry, could you give me that reference?
Sorry, my lord. Page 416. Judgment of Chief Justice Jarvis, just by the lower hole punch, my lords, there's a paragraph starting as a general rule, and the test 3 lines down in that paragraph is whether the cargo can practically be forwarded to its port of destination. And that involves a consideration of all the circumstances, and the word practically comprehends the condition upon which the difference between the partial and total loss contends. The answer in the case was that the cargo could not be practically forwarded in a commercial sense, or it may not have been capable of being so practically forwarded, depending upon all the facts, because various expenses would have had to be paid in order to take delivery of the cargo at the port of destination. And some of those expenses included salvage expenses. So, my lords, again, it doesn't cast any light on the present issue. My learned friends say that it is clear from the reports that the salvage expenses were incurred before the NOA was served. But, my lords, we have looked and we simply cannot see that comes across from the cases at all, or the reports of the cases at all. And my learned friends may try to make that good, but I don't accept that you see that at all from the reports of the cases.
At any rate, it's not suggested there was a discussion of the issue.
There's no discussion of the issue. But
Cases which simply illustrate on their facts, even assuming they do,
it provides
some proposition may not help.
Sorry, my lord. It provides no guidance. Again, it's one of the 2 authorities that Arnold relies upon. This and
Holdsworth.
yes, Holdsworth and Wise, and it provides no support for the position. My lords, I'm not going to say anything more about Yero Karas at this stage, but I may say something in reply about it, depending on what my learned friend says. Lord Reid asked a question about Rura and Forgas, and I think particularly about the idea that the reference there is to the probability and not the event. My Lords, can I just explain that very quickly? It's tab 17 of the authorities file. And the explanation, my Lords, is that the case was concerned with a different section of the Marine Insurance Act. And if your Lordships could turn to 627, a different subsection, my Lords. If your Lordships could turn to 627, there's a paragraph starting as to the first point. About 6 lines down there, the defendant's case that neither element was present. With regard to the external facts, the matter is now regulated by Section 60, which provides, amongst other things, that there is a constructive total loss where the assured is deprived of the possession of his ship or goods by a peril insured against, and it is unlikely that he can recover the ship or goods. So, my Lords, that is Section 62, subsection 1 of the Marine Insurance Act. We are concerned with subsection 2. But the unlikely test explains why Mr. Justice Roche talked about probability and not the event. Because it was incumbent upon in order to claim a CTL under that section, it was incumbent upon the claimant to prove that on the balance of probability, he would not get the goods or the ship back.
That was 60 subsection 2 paragraph 1.
Yeah.
Yes, my Lord.
And we're concerned with paragraph 2.
Correct.
Yeah. And you say it's a quite different
It's a different
scheme.
case, and I'm just picking up on that. That's the reason for the reference to probability.
I mean, the sub-paragraph 2 question, as applied to future expense, is in practice going to depend on probabilities as well, although the word unlikely doesn't appear. What other standard would one apply?
Well, it involves a forward-looking assessment. my Lord.
Yes, well,
Yes.
at least
So-
part of it may,
Yes.
but when you are asking a hypothetical question about costs, some or all of which have not yet been incurred, you are necessarily in the position of having to decide it on probabilities, aren't you?
Yes, make an estimate on the basis of probabilities and applying the prudent uninsured test. Yes.
Yeah. And it's also quite helpful, also the Robertson case where it's approved, in indicating that the reason in a recapture case why there's no recovery isn't that there's not a constructive total loss, but rather that you effectively, once you've had your property restored, you can't expect to be indemnified by an insurer as well.
I would agree. Yes, and with the qualification that there was a constructive total loss at a prior moment in time.
Yeah.
Yes.
Yeah.
My Lords, for all of those reasons, we submit that applying the terms of the Marine Insurance Act and the common law, the correct answer to the first question is that in costs incurred prior to NOA cannot be ranked towards a CTL calculation. As I did say, if you were against me on that wider submission, then on the plain wording of section 62, subsection 2, costs of past salvage operations cannot be ranked. Now, we have submitted, we've made the point that our case is much more general than that, but if our more general case is wrong, then we do submit that our lesser case, based upon the cost of past salvage operations, is clearly right. Now, my Lords, against that background, I want to address very, very briefly the policy wording case that my learned friend
Yes,
says.
you'll appreciate you've now used your allocation of time, so you're going to start eating into your reply time.
Yes, my Lord, that's fine. My Lord, the policy wording argument only matters if you are with me on the Marine Insurance Act and common law position. And the question is, in such circumstances, does the policy wording make all the difference? does it in effect amount to contracting out of what the position would otherwise be under the Marine Insurance Act and the common law? And of course, neither the judge nor the Court of Appeal addressed their mind to that question, because they were against me on the Marine Insurance Act and common law position. The Court of Appeal did not analyse the policy wording at all. On the assumption that I am right as to the position under the general law, the Marine Insurance Act and common law, for the reasons we set out in our written case, there is nothing in the point for the respondents that the policy wording provides a different answer. Section 60 of the Marine Insurance Act provides in terms definitions of a CTL which will apply in any case only subject to the express provisions of the policy. So unless the policy provides differently. And the policy wording here, my lords, does not provide that costs of recovery and repair incurred prior to the date one is considering the CTL question can count. It doesn't say that. The wording does not suggest that the CTL question is to be addressed at the date of the casualty or at any particular time. Neither does it suggest that the purely forward-looking, prudent, uninsured test that applies as a matter of general law is excluded. So, my lords, the simple point is that there is no contracting out of the statutory and common law position in relation to these matters. And if the pre-NOA costs are inadmissible as a matter of general law, they are also inadmissible as a matter of the interpretation of the authorities. And we say that clear wording would be required in a policy to depart from what would otherwise be the position as a matter of general law. And there is certainly no clear wording in these policies. My friends rely upon US cases, my lord, and we address those in our written case, paragraph 82. They are of no assistance for the reasons that we give. The policy wording in this case has to be construed against the backdrop of the Marine Insurance Act and the common law, English common law. And obviously that is not the position in relation to the American cases and the American policy. In any event, my lords, the reasoning in the American cases is unpersuasive and wrong. As to the Armagh decision, the main basis of the decision was that unless pre-NOA costs were rankable, no meaning could be given to the word recovery or recovery. And my lords, that is obviously wrong, as the respondents accept themselves in paragraph 31A of the written case. My lords, as to the Northern Barge Line case, the reasoning is very short, but the policy was construed contra proferentum under American principles, which are plainly not applicable here. And the judge was influenced incorrectly by the idea that an NOA could not be validly given until the cost of recovering the barge had been incurred. As a matter of English law, as I've explained, the NOA can be given at the first moment if the insured wishes to maximise his chances of claiming for a CTL. Finally, my lords, in neither of these cases were the leading decisions of Humphreys and Dickey cited to the court, or the textbooks that I have referred you to. So, my lords, for those reasons, we submit that the policy wording cannot justify a different result if we are correct on either our primary or alternative case as to the effect of the Marine Insurance Act and the common law. My lords, Scopic issue 2, there are two questions. First of all, are Scopic costs of repairs, or costs of recovery and or repair? If not, they cannot be ranked. And secondly, in any event, are the respondents contractually precluded by clause 15 of Scopic from claiming? We deal with the first point in paragraphs 94 to 98 of our written case. The starting submission is that Scopic is nothing to do with protecting the vessel from harm. It is only concerned with protecting the ship owners from liabilities to third parties in respect of environmental damage. And we submit that costs paid for this point or purpose should not qualify. My Lords, the example that we give in paragraph 95 of our written case illustrates the point. In that's the tanker example, where it suffers trifling damage, can be brought to a port of safety and repaired for $1 million. But there are $30 million of potential environmental liabilities that result in a huge scopic award. Now, my Lord, we would say that to hold that the vessel as a CTL in those circumstances would be extraordinary and would be contrary to common sense. The vessel can be brought to safety and fully repaired for a very modest expense, $1 million in our example. And to then say that the cost of repair or the cost of the recovery and repair are 30 million because of the potential environmental liabilities, we say is wrong. And my Lords, a prudent uninsured owner, coming back to the prudent uninsured owner test, faced with such a situation, would not take into account the potentially huge liabilities he may face for environmental damage. He wouldn't take that into account when making his decision whether to repair or to leave the vessel where it lies. And the reason for that is he would continue to be exposed to those liabilities for environmental damage as the owner of the ship, whether he repaired the vessel or whether he left it where it lies. So it's a neutral factor. He would not take it into account in making his decision. My Lords, the Court of Appeal say that it's paragraph 90 of the judgment that because we accept that costs of recovery are costs of repair, that's fatal. They say scopic is an unavoidable part of what has to be paid to recover the vessel. My Lords, in paragraph 34b of the respondent's written case, they say that their own case is that costs of recovery, quotes, necessary to repair, are costs of repair. Paragraph 34b of the respondent's written case. And paragraph 73 of the judgment applies the same test. Costs of recovery necessary to repair. But, my Lords, it cannot be said in this case that incurring scopic costs were necessary to the repair of the vessel. The respondents didn't advance any such case before the judge or the Court of Appeal, and then there are no findings in the judgments that it was necessary to incur scopic costs in order to repair the vessel.
The argument, rightly or wrongly, is that it couldn't be repaired unless released by the salvors. The salvors had a lien, which was presumably for which was substituted a bank guarantee for the whole of the salvage, including the scopic element. I think that's the argument.
Well, maybe it is, but there aren't.
They say it was necessary because unless you discharged the lien, you couldn't repair it.
My Lord, perhaps they are saying that. I'll wait to see if that is their case. But, my Lord, even if that is the position, it's not right to say that the scopic was unavoidable. I mean, the scopic is payable because the owners voluntarily agreed to a salvage contract which contained a scopic clause.
Yes, I mean, your counter to Lord Sumption's summary of the case against you is, well, they didn't have to enter into that particular salvage agreement in order to recover the ship. Therefore, you say a natural interpretation of the prudent uninsured owner test is that you only enter into an obligation to get the ship back, to pay as much as you need to get the ship back, and scopic is extraneous to that.
My Lord, essentially, yes, and it wasn't necessary. There is no finding that it was necessary for them to enter into an agreement on these terms in order to repair the vessel. They chose to do so because doing so improved their position potentially as regards liabilities to third parties for environmental damage.
Well, is it in practice possible to make a salvage agreement without a scopic clause, bearing in mind that the salver himself may incur liability for pollution damage.
My lord, there's no. I can't give evidence on that. There's no finding that it is not impossible, and it's a matter of negotiation between the owners and the salvor as to the terms. I mean, there are cases where the agreement is on day rate terms.
That doesn't tell you what, maybe on day rate terms, it doesn't tell you what the salver is going to do on each of the days which he's remunerated for.
No.
I mean, surely a better point is simply that the characterization of this expense, whether necessary or not, is not the characterization on the face of it required by section 60 sub 2.
Yeah.
That's your case in all simplicity, isn't it?
My lord, it is, but it is absolutely, but we do say it can't be said that they are costs necessary to repair in any event. My lords, I'm conscious of my limited time. Can I just refer also to what is said in the Angel case, and I'll give you the reference. It's tab 1. Volume 1, tab 13, page 575. And in this part of the judgment, Lord Justice Matthew was dealing with costs that the owner could rank towards his CTL calculation. And he holds that...
tab 70, did you say?
Tab 13, my lord.
Sorry.
Page 575. And it comes back to the point that Lord Sumption asked right at the outset about was there P&I insurance in respect to scopic costs? And the answer is yes, there was, and it was paid by the insurers, as everyone would, paid by the P&I insurers, as everyone would expect. Now, what Lord Justice Matthew says in this case is that certain sums that were claimed to rank were covered by separate insurance that had been taken out to cover the voyage from Malta to the home port, and that they could not be ranked. The judge held that they could not be ranked because they were charges which the owners would not charges which the owner would have to meet. And we say that same sort of a reasoning applies here, my lord. Scopic costs are not charges which the owner has to meet because they are covered by his separate P&I insurance. The idea being
there are charges that he has to meet, but in respect of which he's indemnified.
He's indemnified, but the same applied here, my lord. These are charges which are covered by separate insurance.
But there is, I think, authority that if something is part of the costs of repair that is subject to a specific exclusion in the policy, it may still rank for CTL. But that may not be the same question as whether it's part of the cost of repair at all.
There are first instance decisions both ways on that separate question. The other point on scopic is clause 15 of the scopic provision. And we say that is a contractual provision that we can rely upon under the Contract Rights of Third Parties Act. And if we're right on that, the question arises, is it sufficiently broad enough to preclude the owner's ranking scopic cost towards a CTL calculation? Now, my lord, surprisingly, a jurisdictional point is taken by the respondents in their skeleton paragraph 120. Said that the scopic clause provides for arbitration and that we're not entitled to rely upon this defence before the courts. My lord, that point was raised by the owners before Mr. Justice Knowles, and he did not accept the point, but instead went on to decide the substantive issue. The owners did not raise the same jurisdictional objection before the Court of Appeal. On the contrary, they dealt with the substance of the point, and the Court of Appeal went on to address the substance of the point. So there was no ground for an objection, which I will explain if necessary in reply. But in any event, the point is not open to owners before this court. So as to the substance, we address our submissions shortly on that in the written case. The language of clause 15 is of the widest import, and we suggest it's intended to make clear that Scopic should not in any way enlarge or affect the liability of Hull and Marine insurers arising out of a casualty. And for the reasons that we set out in our written case, paragraph 100, a claim for CTL that includes as an integral component Scopic costs is easily covered by the very wide language of clause 15. Scopic remuneration is integral to the action. It is a necessary component of it. The language is no claim concerning Scopic, direct, indirect, by way of indemnity or recourse or otherwise, can be made on the H&M policy. And it is difficult to see what those wide words can have been intended to cover, if not a CTL claim taking into account Scopic. The Court of Appeals say, well, ranking costs do not have to, in fact, be incurred. But that is no answer, my lords. Certainly in this case, the Scopic costs were incurred, and the owners seek to rank them in their CTL calculation. They include them in their claim for a CTL. And picking up finally on paragraph 122 of the respondent's written case, it is no answer to say that the CTL is a claim for an indemnity and that relates to the total loss of the ship. Because it's no answer, the reason is that the claim for a total loss, CTL total loss, is premised upon the costs of repair, including Scopic costs.
Yes, but there's no recovery of the Scopic costs.
There's no separate recovery.
There's no recovery at all of the Scopic costs. On their case, it's simply an element in the determination of what sort of loss has occurred. And if they're right, then it's a constructive total loss, and the indemnity is in respect of the value of the hull, and that's an end of it.
My Lord, we're not saying it's a claim, looking at the language of clause 15, we're not saying it's a claim by way of indemnity.
There's no indirect recovery.
For
Simply by taking it into account so as to trigger a CTL, you don't alter the nature of what it's a recovery for. So it's not inconsistent with Article 15. The relevance of Article 15, surely, is that it tells one pretty conclusively what the correct characterization of a Scopic cost is.
My Lord, I do obviously rely on it for that purpose as well, but clause 15 covers a claim by way of indemnity or recourse or otherwise relating to Scopic. And you have my submissions that making a CTL claim in which you rank Scopic costs is a claim that is covered by that very broad language in clause 15. My Lords, issue 3, as I said, we've addressed this in writing. On the large margin point, we have said in writing that the point is simply not open to the owners before this court. That is because the judge determined what he regarded as an appropriate margin to add. He said 10%, and there has been no appeal on that point to the Court of Appeal or to this court, and that is the end of the matter. So, my Lords, if we succeed on issue 1, there is no basis of remission to the judge.
You succeed on only issue 2. I think you accept that there would have to be a remission to the judge.
My Lord, we do, but not because of the large margin point, because of a separate point that the judge didn't make findings in relation to all of the costs of repairs. My Lords, thank you for indulging me with a little extra time, and I note that it will be taken into account in relation to my reply. Unless you have any other questions, that's all I wanted to say at this stage.
Very much indeed. Mr. Pearce, do you follow? Mr. Berry.
Thank you, my lord. I will deal first with costs before NOA and then come to stop it afterwards. And the structure of my submissions is that there are 4 chapter headings.
Mr. Berry, would you mind speaking up?
Certainly.
Those of us who are at this end of the court.
There are 4 chapter headings to my submissions. The first is the wording, both of the Act and the policy clauses. And my submission on there is that one or other or both resolve this appeal on the pre-NOA costs in favour of the assured. My second chapter heading is that the correct rule, if the matter is in doubt, as a matter of justice, is a rule that includes pre-NOA costs in the CTL calculation. And I will deal with my learned friend's submissions about justice or injustice in that context. My third chapter heading is can be summarized as logic and principle. And my submission there is that the essential logic and principle of a CTL claim requires, in a case such as this, and generally we submit that pre-NOA costs are included, and in considering those items of logic and principle, I will first deal with what we say the logic and principle is, and then secondly deal with my learned friend's points in this area, and mention the authorities that illustrate the logic and the principles, not because they expressly determine the very question before your lordships, but because the logic and principle which they illustrate themselves determine that question. And then finally, I will consider the authorities that could be said to directly relate to the questions that are before your lordship. And so, may I start with the wording? Within that, I start with the wording of the Act, which your lordships may have in Bundle 2, tab 70 or elsewhere. And then I will move on to the clauses, which we can find quoted in the various submissions. And in my submission, this is the beginning and the end of the point. Subsection 2, subsection 2 provides that in particular there's a constructive total loss, and then little Roman 2, in the case of damage to a ship, where she is so damaged by a peril insured against that the cost of repairing the damage would exceed the value of the ship when repaired. Now that directs the reader and the lordships to the time at which she is damaged and asks a hypothetical question relating to that time. Is she so damaged that the cost of repairing would exceed the value of the ship when repaired? And it is essential that in this wording there is no limitation to the cost of repairing, and in equivalent terms there is no limitation to the cost of recovery and repair that is what gives you a CTL in clause 19.2 and the other clauses. And really, it's as simple as that. And a brave counsel would now sit down. But I'm not that brave, and so I will move on. Indicate that the next part of that, in estimating the cost of the repairs...
So you say, in the case of damage to a ship, implies that you ask the question as it stands at that time.
Whenever you ask the question, and my Lord Sumption has analysed it correctly, if I may say so, whenever you ask the question, which is at the NOA and at the date of writ, depending on circumstances, the question you ask is, was the ship so damaged that the peril insured against the damage would exceed the value of the ship when repaired? And with respect, one of the fallacies, there are many, but one of the fallacies in my learned friend's submission is to elide the time of asking of the question with the question. The question is section 62 sub 2 satisfied? And that is satisfied where she is so damaged that the cost of repairing would. And I'll come back to when dealing with his logical case, his principled case, I'll come back to the would, but just as a precursor submission there, the would doesn't mean would in future. The would means hypothetically today, if repaired today, what would it cost? And so fallacy number one is this future-looking business. I'll say that fallacy number two is the date of the NOA business, and fallacy number three is that the prudent uninsured test makes any difference. But I'll come back to that. So, my Lord, you're simply directed to ask by this wording, is it a cost of repair? And there's no limitation to that. And my learned friend seeks to imply the words, the cost of repairing future to NOA. But without those words, he loses, and there's no reason to imply those words, not least because, as has been repeatedly pointed out, CTL or not is independent of even the existence of hull insurance and is independent of the giving of NOA. The NOA is merely, as has been repeatedly stated, an election between the two remedies that you have where she is so damaged that the cost of repairing would exceed, which by reason of the next but one section, you must make that election within a certain... By reason of section 61, you must make the election, and by reason of section 62, you must make it within a certain time. That is conclusive in our favour, we submit. And indeed, the true nature of my learned friend's case appears from paragraph 60 of his written case, which is page 75 of section 5 of the core bundle, where he says that the word future implicitly excludes costs before the NOA, and that is the true nature of the case. Now, I'll come to future salvage when considering the wording, but essentially, I would invite your lordships to say that the judgment of Lord Justice Hamblin, at paragraph 69 to 72, of the judgment, that's page 163 of the appendix, and the judgment of Mr. Justice Knowles at paragraphs 31 and 38 to 40, that's pages 180 and 181 of the appendix, are impeccable on this point. They say, look at the wording, it says cost of repairing, and that naturally means all cost of repairing without limitation. Insofar as my learned friend says that section 91, subsection 2 of the Act preserves the common law, and insofar as he makes arguments based on the common law, and insofar as they are correct, which we dispute, then section 91.2 makes it clear that the Act prevails if inconsistent with the common law. And so if I am otherwise wrong about the common law in the submissions I'm about to make, then it doesn't matter because the Act is inconsistent with it as interpreted as I've indicated. And therefore, for that and other reasons, my learned friends delving into the 19th century and conferences at Buffalo, that doesn't actually assist. Now, so far as the wording is concerned, the context is that the institute clauses were introduced in 1983, many years after the Act, and not in exactly the same terms as the Act.
Current edition of them was.
There was an edition in 1983, and then there was a further edition in 1995, and the wording is materially the same, but the policy in this case, my lord, is the 1993 version, i.e. the first iteration. And they include the words that you can see, recovery and repair is essentially, I won't take you to them. And the context is that they were written against what we submit is the general practice of allowing pre-NOA expenses in a CTL. And might I make that good by inviting you to look at the Authorities Bundle section 2, tab 55. Which is the third edition, it's dated 1996, of a book called Goodacre about marine insurance claims. And he, Mr. Goodacre...
Sorry, could you give me that reference again?
I'm sorry, Bundle 2 of the Authorities, tab 55, and the page is 1361 of the bundle, if you can see it, which you probably can't. And at page 1363, which has been copied from the bundle, so I was going to say that this is from a member of Marine Claims Services. He was chairman of the Society of Average Adjusters, and he deals with this sort of issue day to day, or dealt then with this sort of issue day to day. And at 1363, he quotes the clauses, the material one of which is 19.2, and talks about the cost of recovery and repair, unless such cost would exceed the insured value. And then over the page at 1364, he refers to Hall and Hayman and the Medina Princess as points of legal question. But it's after that, he says, in practice, it is generally regarded that consideration must be given to all expenditure required to put the vessel in order from the time of the casualty, and obviously some salvage operations have to be undertaken on occasions before the assured is in a position to know whether the vessel is worth repairing. This practice appears to be approved by Arnold and receives strong support from Lord Donaldson. So, my lord, the context, I would submit, in which the 1983 clauses were introduced, and the context in which our contract was written, was that it was the general adjusting practice deemed to be known to the participants in the industry, such as my clients and Mr. Ashworth's clients, that these were generally allowed. And but in any event, I submit primarily that the wording is clear.
But they had been allowed, as I understand it, long before the words recovery and or were introduced in 1983.
That is true.
Yes. They had been allowed on the footing, I think, that what is meant by repair is the entire cost of reinstatement of the physical damage to the vessel.
From the casualty, yes.
Exactly, that would include getting it off the rocks.
Yes. Yes.
So that really the Institute clauses simply made express what had been the law decided by the courts for quite a long time.
And the practice. And if your lordship is with me on the law, then I don't need the Institute clauses. But if there's any doubt about the law, then I would adopt that submission that the Institute clauses, against the background of the practice, as incorporated into our contract in 2012 or 2013, makes clear the point if it would otherwise be open to doubt.
Well, it doesn't help you on the timing point, does it?
Well,
it helps you to establish that salvage costs are in principle to be included, but it still leaves open the argument against you only if they are incurred after NOA.
Well,
because you could give NOE, as this is the argument, you could give NOA the moment you hear of the casualty. Indeed, if Mr. Ashcroft is right, everybody will start doing just that.
Well, they will if your lordships say he's right, but I'll show you authorities that say the Aero Caris says that that's wrong and the notice is invalid. But
because it's got to be made in good faith, or
because under section 69.3 it has got to be made after receipt of reliable information, alternatively after a reasonable time.
After receipt of reliable information about what?
The loss.
Yes.
And the loss in...
Say that means...
A CTL.
That means you would have had a survey in dry dock and all the rest.
That was the decision of the judge and the Court of Appeal, which is not appealed against before your lordships, which is that on the facts of this case, there was no reliable information, as my learned friend has shown you, even unto the end. Yeah. Of course, when that happened...
That was for the purpose of the waiver election point.
And also the delay point. Perhaps I can explain, without going back to the judgment, I can explain that to your lordships by reference to sections 61 and 62(3) of the Act. And your lordships see these sections, 61, and by the way, these sections apply to ship and cargo, all forms of insurance. The effect of a constructive total loss, section 61, where there is a constructive total loss, the insured may either treat the loss as a partial loss or abandon and treat the loss as if it were an actual total loss. And although the word election is not there used, it is an election and has been so described in various cases, including one called the Castor 2. And then at 62, notice of abandonment, subject to the provisions of this section, where the assured elects to abandon, he must give notice of abandonment, and and the time at which he must give is in subsection 3. Must be given with reasonable diligence after the receipt of reliable information of the loss. That is the primary rule. But there's an alternative rule in case that is not achieved, and that's this: but where the information is of a doubtful character, the insured is entitled to a reasonable time to make inquiry. And the decision of the Court of Appeal was to the effect that where you don't have reliable information, and I would say the judge, where you don't have reliable information, you must make your election after a reasonable time to make inquiry. And it was held in this case that we made our election and gave the notice of abandonment within that reasonable time. And so, to come back to Goodacre, and to answer my Lord Sumption, my submission about what Goodacre says is that it deals with work done before the date of notice of abandonment, and says that the practice has been to include that.
Yes, the text of the clause covers recovery as well as repair, which, as Lord Sumption says, may have been implicit anyway. Yes. But the commentary, as you say, it looks at Hall and it looks at Medina Princess and says, notwithstanding that, this is the practice. Yes.
I.e. to do what we submit is the right thing to do in law here.
Yes.
And my submission is that is right under the clauses. I've already submitted it's right under the Act.
Yes.
Might I, and for the years since the clauses have been instituted, so far as researchers indicate, no underwriter has ever taken the point that my learned friends take here, notwithstanding the practice indicated in Goodacre. And as we submit in one case, that includes in brutally fought total loss cases, such as the Brillant Virtuoso, where the London market, instructing highly experienced marine insurance solicitors and counsel, simply didn't take the point. And the answer must be that the practice has been regarded as correct ever since the clauses, whatever might have been the position in the Medina Princess and Hall and Hayman predating the clauses. Now, so far as construing the clauses is concerned, which your lordships probably have in a number of places, but the Goodacre book is a convenient place for them. Alternatively, my learned friends' submissions quote them at paragraph 13, page 59 of the core bundle, tab 5, but you'll have them quite well in mind, but for the present submission, I think I need to look at the precise wording. And in my submission, then, as a matter of contractual interpretation, there is no limit to post-NOA costs. And as a matter of contractual interpretation, one would only imply a limit if it satisfied the strict test or the test of necessity that I won't develop before your lordships, because there's a lot to say on them. My submission is it's essentially a test of necessity, no need to imply. And as to the construction, I do invite you to treat as persuasive and to come to the same decision as in the two American cases that my learned friend adverted to briefly. The first is the Armar in Bundle Authorities 2, tab 38, if I may. And recalling my learned friend's submission, that one of the problems with this is that it is American law, not against the background of the Marine Insurance Act. So we'll see the extent to which that's accurate. But in the Armar, Authorities Bundle 2, tab 38, page 1252, in the head note, 95 of the Lloyd's reports, and that's the English Lloyd's list reports, page 1252 of the bundle, the clause is there quoted, no recovery for a constructive total loss shall be had hereunder unless the expense of recovering and repairing the vessel shall exceed the insured value. And in my submission, that is materially identical to clause 19.2 that we have here. And then if your lordships merely look over page at 1253.96 of the report, your lordship will see that the Lloyd's reporters record that the following English cases, among others, were those cited. And at least in one respect, my lord, they were wrong to say that, because the sailing ship Blair Moore is not an English case, it's a Scottish case. But on the other hand, it proceeded on the assumption that Scottish law on the point was the same as English law. So perhaps the editor can be forgiven.
It's a common confusion among
grievous error.
Scotland is part of England.
Not at Lloyd's, one would. And if your lordships then look perhaps at 97, just not at the text of it, but in the left-hand column at 97, at the first full paragraph, in the calculation of repair and recovery, it's proper to include expenditures necessary to deliver the ship from peril. And that's my Lord Sumption's point, that repair and recovery has always included getting it to where you can repair it. And then they cite a US case, but they also cite an English case, North Atlantic, in the commercial cases reports. And then they cite Hall and Hayman, with which you're familiar. And then they cite Templeman. And then they cite Arnold. And then they cite Aganoria, another English case. And the reason for this, if we can go forward to page 1258 of the bundle, page 101 of the report, and he's dealing now with a partial loss claim, but the reason for this can be seen in 3 lines at the end of the citations in the right-hand column at page 1258. That federal law here, uniquely enough, refers to the law of England. And that is the beauty of the English law of marine insurance. It pervades the Americans as well. So my learned friend's point that it's not settled against the background of the Marine Insurance Act is simply wrong. And indeed, one can see here, if one looks at it, that they did actually look at the Act as well as the English cases on the Act. One can see that at 1258 in the middle. In the circumstances of this case, section 69.3 of the Marine Insurance Act applies. So my learned friend, with respect, is wrong to say that these cases are to be distinguished on the basis that it's American law, not against the context of English marine insurance law. However, wrong as he is, the reasoning stands on its own, whether that's right or not. And the reasoning is at page 100 of the report, 1257, right-hand column, in the first full paragraph, which says that in determining whether under the policy the vessel may be deemed a constructive total loss, we must add the amount to the amount found proper to repair the vessel, a sum representing items not already included and which may properly be included within the meaning of recovering and repairing, as appears in the policy. The plaintiff's claims include various items, and there was a bill of particulars, and then 4 lines down, the defendants present a blanket objection to certain of those items or portions of items, on the grounds that they were incurred prior to the date of notice of abandonment and therefore may not be taken into consideration in computing a constructive total loss. I do not consider the point well taken, because if we are to give the word recovering any meaning, those items must be included. And so here I invite your lordships to find. And just for completeness, that was Judge Rabin in the Supreme Court of New York, which isn't the Supreme Court of the United States. It's a first instance. It's the, if I can summarize it, the highest first instance court in New York, which deals with these matters. So I wouldn't want to overstate the level of this authority, but it was reported in the Lloyd's reports and has been in Arnold for many iterations. And then the next tab, 39, is the Northern Barge case of 1974. And essentially, the facts were that there was, very similar to our case in our submission, that there was expense in recovery expense pre-NOA, held that the wording includes that. And the Chief Justice of the Northern District of Iowa, in the middle of the page, there seems to be a line in the photocopy, just above that line. Defendant replies that plaintiff is precluded from adding in the recovery expenses because of its failure to tender abandonment of the barge to the defendant until after they had been incurred, i.e. my learned friend's point here. And then it is said that abandonment is necessary, prerequisite, and the defendant asserts that a determination of such loss may only be based on the prospective expenses of recovery and repair as they appear at the time of the abandonment. And if you exclude recovery, there's not a total loss. This then is the question which must be decided. Can plaintiff include recovery expenses incurred prior to abandonment notice in determining whether there was a constructive total loss? The parties' briefs treat this question as one which must be resolved under common law. And then there's a footnote 3, which is over the page. Additionally, the defendant cites Section 60 of the Marine Insurance Act. Apart from the fact that this is English law, Section 60 does not seem particularly helpful to the defendant here, the defendant being the insurer, and it does not specify that abandonment must occur prior to any expenditure, but rather only that abandonment must be on account of the cost. In other words, if I can summarize it, his lordship there, although saying it's not part of the ratio, is agreeing with the submission that I am making about the Act. And then back at page 1260, viewed as such, that means the common law, the issue becomes a nice legal problem. You know what I say the answer to that. Whose resolution under the arguments made is arguable. And then footnote 4, plaintiff seems quite clearly to have the better of the argument. Another submission that I invite the lordship to accept. But then he says, it's not necessary to venture into this particular thicket since the language of the policy is controlling. He quotes the language, and he says the inescapable effect of this language, which is necessarily subject to the principle of contra proferentum, is that an actual determination of the expenses of recovery and repair must precede allowance of a claim for the CTL. Now, it's fair to say that to the extent that there is assistance gained from the principle of contra proferendum, I can't pray that in aid here, but I pray in aid the inescapable result of the language. Well, I see it's 3:20, and there was a suggestion of a short break. I don't know if that applied to the afternoon session.
No, I think you can carry on, Mr. Berry. Thank you.
So those then are my submissions on the wording. Now, my submissions on the just rule, and in this court, in my submission, this is a relevant consideration. And our submissions on that are in paragraph 39 and 96 and following of our written case. And we also rely on Lord Justice Hamblin at paragraph 74 and 75 and Mr. Justice Knowles at 34 to 36. And in essence, the point is that it would be unfair to an assured to exclude pre-NOA costs in circumstances where it may be necessary for him to expend costs pre-NOA in order to ascertain whether or not he has the right to elect, provided for Section 61. And that, in effect, the rule that my learned friend contends for would be to exclude necessary costs for the purpose of deciding whether you can elect, so that in spending money to decide whether you can elect, by that very expenditure, you lose the right to elect. And that is simply not fair, and that's the point that's been repeatedly made, rightly, by Lord Justice Hamblin, Mr. Justice Knowles, Lord Donaldson in his talk, Arnold in their material, and Goodacre from the point of view of the loss adjuster in what I have shown your lordships. But my learned friend says that, well, he can cure that potential injustice by giving protective NOAs the minute he hears of a casualty, before the salvor goes, before anyone incurs any cost. And in my submission, whether he can or not, which I'll come to in a minute, a rule that would require him to do that before electing is an unjust one, because he may want to keep the ship if it is undamaged. And it is not an uncommon situation that the ship is worth keeping, notwithstanding that there's an insured value. It is only that in most of the cases that come before the courts, they come because the insured value exceeds the real value, but in which case there isn't going to be any litigation, usually. But in the Robertson case, we'll see in a minute, such was the position, and the insured elected to repair, even though the vessel was a CTL, in those circumstances because the market value exceeded the cost of repairs, even though the cost of repairs exceeded the insured value. And my learned friend's rule would deprive owners such as that in Robertson of the possibility of keeping the ship by requiring them to give notice, which the underwriter would then, on those facts, with alacrity accept, before he knew of the true damage. And we'll come to Robertson in a moment. Your lordships have seen section 62, subsection 3, and what it says as to the time of election. And my learned friend mentioned the George Cohen case. Can I invite your lordships to look at the Yarrow Karras case in Authorities Bundle 1, tab 20. Now, there are 2 points to this case which I would rely on. The first is that the ineffectiveness and invalidity of premature NOA, and the second is that the pre-NOA salvage costs were allowed on the basis that there was a lien for them. But my submission is that why does that make a difference when, in a case where a lien is replaced by, for example, a guarantee, which would be an entirely usual position. And in fashioning a rule, your lordships are looking, I would submit, at the kind of case that one could normally expect to happen. They include salvos having a lien and salvos charges being guaranteed. This is a case where if the salvo has a lien, the pre-NOA salvage costs were allowed, and that should, in my submission, be the general rule.
But, I mean, are you submitting that even if the salvage expenses were not to be taken into account, if they're secured on the hull, then they are to be? The security can make all the difference to the characterization. You're not suggesting that, are you?
I'm suggesting the opposite.
Yes.
I'm suggesting it should not make a difference. My learned friend is suggesting what your lordship indicates, because he says the explanation of this case is that the salvage was secured on the hull. And he says, aha, not so in the case of the Rhinos.
That's not what he's submitting in relation to the scopic costs.
Quite. Well, there's therefore tension between what he says about scopic and what he says about pre-NOA, which I'll come to exploit, if I may, if that's the right word, later. The key to understanding this case is in the date, so if I may just perhaps take a little time at page 699 of the bundle before going to the principle. In the judgment of Mr. Justice Porter, who was always doing cases of this nature, as we'll see, and in the middle of the left-hand column at 699, perhaps I can just give you the key dates. So, in the middle of the large paragraph, in the middle of the left-hand column, on her way through the Straits of Magellan on November 13, 1930, she's stranded on a rocky bottom. Next key date is 16th of November. By November 16, Salvors, the Magellanus Salvage Company, and Mr. Dixon, the Lloyd's agent, were on the spot and signed the Lloyd's salvage agreement, no cure, no pay. The next key date is in the next paragraph. So salvage, as it were, commenced by then. But the next key date, on the 17th of November, notice of abandonment was given to the underwriters on the ship. The next key date is the next key date is, skip over a few dates, December the 18th, 1930, sorry. She arrives at Magellanes, and then on the 22nd of December, Mr. Gray, who is instructed by the underwriters, starts his survey, and thereafter the owners didn't like the survey and the arrival survey. So those are the key dates. The key point is that the notice of abandonment was given there in the way that I think my learned friend would say it ought to be. At the bottom of page 40 of the report, 701 of the bundle in the right-hand column, his lordship says this under the letter A: it was argued on behalf of the defendants that no prudent owner would have abandoned the ship as she lay on the rocks at Baker Cove, or in Baker Cove, and that on the admitted facts there was no real material upon which to make up the mind until she reached Magellanes. In other words, the first time reliable information was received was 18th of December at Magellanes. And then the object of this argument is, of course, in order to subtract from any cost of repair the salvage expenses in floating the vessel. Since, if the argument is sound, no abandonment could rightly take place until after these expenses had already been incurred, and as the only expense of future salvage operation is to be taken into account, these past salvage operations must be neglected. So that was the argument. Some discussion took place as to the meaning of future salvage operations. That is to say, what was the event to which such operations were future, the accident or the date of the abandonment? I do not find it necessary to determine that question. So it was an open question in 1936 whether future meant future to the casualty or future to the notice of abandonment. And that's material when my learned friend later says, oh, everyone's always assumed for hundreds of years that it's future to the date of abandonment. No, the point was raised and not decided by Mr. Justice Porter in 1935. And then he makes the point that we've been discussing. I accept the view that even if the moment of the ship's arrival at Magallanes is the first date on which the abandonment was permissible, still this ship was there in the hands of the salvors, and in order to regain her, the owners would be obliged to pay off the salvors and discharge their lien. I make my submission now so I don't have to repeat it later on. That is an allowance of pre-NOA salvage where there is a lien on ship. Surely the rule cannot be different, where, for example, a different kind of security, such as guarantee, is given. Therefore, the rule ought to be all pre-NOA costs, albeit I accept this is not authority for that proposition because that was his ratio. And then in the right-hand column of 42, page 703 of the bundle, and this is where we go back to the premature NOA point. Near the top of the page, bearing in mind the considerations set out above, those being various legal principles that he's recited.
Sorry, we're on 703.
I'm sorry.
Right-hand column.
703, right-hand column,
column,
first full paragraph after a quotation from Corey and Burr, or North Atlantic and Burr. But bearing in mind the considerations set out above, the first question to be considered is whether the abandonment of the ship was justified at the time the notice was given. And you'll recall that was 17th November, the day after the LOF was signed. I do not think that it was. It was given as a measure of precaution in case the vessel should ultimately prove a total loss. And then he discusses whether there was in fact a total loss. He says, in my view, no prudent uninsured owner founding himself on the facts as they existed on November the 13th could have said, in the words of Lord Ellenborough, that a total constructive loss was in the highest degree probable at the time. No satisfactory opinion could then be formed. The earliest time at which a judgment could be formed was, I think, when the vessel reached Magallanes on December the 18th. So what does he do with that 17th of November notice of abandonment? He ignores it as ineffective because, as you see at the bottom paragraph at 703, had then the ship become a constructive total loss at the time she reached Magallanes, and addresses the question as at that point. Now, if my friend, that shows two things. Firstly, a premature NOA is simply invalid. And secondly, therefore, that it would not assist the owner out of the unjust dilemma caused by my learned friend's rule. Because if he gave NOA the minute he heard the casualty, the underwriters would turn round and say, you didn't have reliable information at that time, you can only give reliable information afterwards. He would add, as a matter of the utmost good faith, you can't give an opinion that you've got no basis for, but that's very much an additional point. That NOA is invalid. You can't give a valid NOA until you have adequate information, on the facts here, Magallanes. But by then, you've spent the money to put you in the position to get the adequate information, and on his rule, it doesn't count. What a nasty trap. I mean, there's also the point that, the reverse point, that if on the facts, for example, of Robertson and Nomikos, you give notice immediately and it turns out the market rate is gone and the ship isn't actually damaged, you then lose your ship at less than its true value. But that's Mr. Justice Knowles' point, and a perfectly good one. Now, my learned friend's case on justice is in paragraphs 50 and following of his written case. I won't go there, but they are all instances of trying to deal with unreasonable conduct or unreasonable delay by the owner. So the injustices he posits from the rule that we contend are in fact cases where the owner has behaved unreasonably, in which case, because of the prudent uninsured test, he wouldn't be allowed to count the expenses anyway, because you can't count unreasonably incurred expenses. Or, by reason of the rule in section 62, subsection 3, he would lose, by dint of unreasonable delay, his CTL claim in the first place. So the justice of the case, as so many judges have recently, and commentators have recently said, is all one way. And if I can simply give you the reference to the 16th edition of Arnold, paragraph 1203, which is authorities to tab 42, page 1268 to 1269. That's Lord Mustall's edition.
Pages, sorry?
1268 to 1269 of the bundle,
68,
paragraph 1203. That's Lord Mustall's, and he makes the point that you have to incur expense in order to know whether you... And it's repeated in later editions, but since my learned friend makes comments about editions of Mr. Gilman, I won't worry about those. And as I say, Hamblin 74, paragraph 74, and Knowles at first instance, J at paragraph 34, makes those points.
Sorry, Knowles at?
Mr. Justice Knowles at paragraphs 34 to 36, which is the appendix at page 180, and Lord Justice Hamblin at paragraph 74 to 75, which is the appendix at 163 to 164. I'm essentially, I'm doing it this way because I make my submissions, and then I say, look at what Mr. Justice Knowles and Lord Justice Hamblin said, and they are essentially brief but valid endorsements of the submissions I've just made. Now, principle and logic that we advance. First, the existence or otherwise of a CTL is an objective fact, independent of NOA or even insurance. And that's important. Secondly, that notice of abandonment is not part of the definition of a constructive total loss, but only an election between two remedies for that loss. The third important principle is that money spent by the owner itself in recovering, which is generally what we're talking about here, does not reduce the owner's loss, or put another way, in the words of Lord Mansfield, doesn't reduce his damnification. And equally, although this is more a justice point, is likely to be necessary.
Which case is that a quotation from?
Hamilton and Mendes.
That was the capture and recapture case.
It was, yes. Which is the origin of the principle that my learned friend relies on, that it must be a total loss both at the date of the notice and at the date of the writ.
In fact, it was an odd case because the news of capture and recapture simultaneously.
I'm not that may be right of that case, or maybe Bainbridge I'm thinking of, but quite. And a question that your lordships may have to grapple with is whether that being the basis of the principle that the vessel should still be a CTL at the date of NOA, whether that principle applies outside the capture and recapture cases, to which entirely different considerations apply. And I will submit, if that principle is what my learned friend says it is, then it shouldn't apply outside capture and recapture. But I'm getting ahead of myself. The fourth principle, general principle, is that a valid NOA dates back retrospectively to the casualty.
I'm sorry, I didn't hear that.
If there's a valid NOA, it dates back retrospectively to the casualty. That is to say, the loss occurs at the date of the casualty. And in that context, in the context of those 4 points, can I invite your lordships first to, probably first and more or less last, to look at Robertson and Nomikos, which is Authorities 1, tab 22. At 722 of the bundle, 371 of the report, one has the facts, and they were that the respondents, the ship owner, was insured in respect of the hull, so he had hull policy, and he also had, in the first line of the head note, the respondents had the hull machinery on the policy at a value of £28,000, and on time terms for 12 months, and he also had a Lloyd's policy in respect of the freight, 4,100, and then, £4,110, Mr. Hart corrects me, and then clause 5 of the freight policy is that in the event of the total loss, whether absolute or constructive of the steamer, the underwriters will pay the freight policy, and then at the end of that paragraph of the head note, warranted free from claims consequent on loss of time. So those are the essential building blocks of the policy. And then if I can just go to the facts, 723 to 725 are the facts, and at the bottom of 724, one sees the important dates. The first important date is 31st of October 1936, when there was a violent explosion and fire a little bit out of Le Havre en route Rotterdam. The plaintiffs obtained tenders for her repairs, the lowest being 37,400 L. And the plaintiff estimated that owing to the increase in tonnage values, the steamer, when repaired, would be worth 45,000. So if the owner there had said on the immediate explosion and fire, I tender notice of abandonment precautionary, he would have given, the underwriter would have said, thank you very much, he would have given away a vessel worth 45,000, where the repair cost was only 37,400. Anyway, they decided on December 18, so that's the next date, to accept the tender and not abandon. So the insured elected to not abandon. They claimed for a partial loss on the hull policy and got that. The repairs were completed in May 1937, and then in February 37 they claimed under the Institute freight clauses on the freight policy, the condition of which was that the vessel was a constructive total loss, the relevant date for which is of course the date of the writ in the case of no notice of abandonment. And at page 728, can I just run through the sort of forensic or the authoritative position here? At page 728, Lord Atkin agreed with Lord Wright and Lord Porter. At page 729 of the bundle, Lord Thankerton also agreed with Lord Wright and Lord Porter. And then if I can just invite you to go forward to the last page, 747, Lord Russell of Killowen agreed with the two opinions just expressed, which were Lord Wright and Lord Porter. So each of Lord Wright and Lord Porter's judgments had 4 of their lordships, and 3 of them being Lord Atkin, Lord Porter, and Lord Wright. I may venture to suggest a powerful constitution. Now, if I can invite you then to look at 731 of the bundle in the judgment of Lord Wright. The last line on that page the principal objections raised by the appellant to the claim were that there was not a constructive total loss of the vessel because there had been no notice of abandonment by the owners who had elected to retain. And secondly, that in any case it was excluded by Clause 8 as being a claim consequent on loss of time because the repairs took so long. 2 points. And Lord Wright, his opinion was that the appellant fails on both, and essentially in that page, I won't read it word for word, but he finds that that notice of abandonment is not an essential ingredient of a constructive total loss. One can perhaps take it 6 lines from the bottom. Therefore, there was a constructive total loss at the relevant date. They didn't go into date, there just was a constructive total loss. Then at 733, he explains further, 5 lines down, the section makes it clear that the right to abandon only arises when there's a constructive total loss in fact. That is the necessary precondition to a right to abandon. The frame of the section makes it impossible to treat the right to abandon as identical with the constructive total loss. It is a superimposed right of election where there is a constructive total loss, nor is it even a necessary ingredient of a constructive total loss because it may be treated as a partial loss. And just to note further, because I'll be making submissions on RORA and Foregas, at the bottom of 733, he says that the conclusion that there's a constructive total loss agrees in principle with the decision of Mr. Justice Roche, as he then was in RORA and Foregas, about which I'll be making submissions. 10 lines down, he is here, I would submit, approving Mr. Justice Roche's interpretation of section 60, subsection 2, that the test was external and objective and did not depend on the owner's election. And then he makes the point that there may not even be hull insurance at all.
And he said the same thing about section 61 on the previous page.
Yes.
But it's an objective definition,
Yes.
and it is quite distinct from the right of election.
Yes. And the question I ask then is how can the notice of the election determine takeaway rights, the timing of it takeaway rights? Can I just go to page 738? Coming to what I might call the retrospectivity point. His lordship, Lord Wright, says at 738 of the bundle, which is 387 of the report, and he's now considering the clause 8 defence, that it was excluded because it was to do with delay. 6 lines down, he says, I do not think that in the facts of the case the claim was consequent on loss of time within clause 8. Clause 8 must be read with clause 5. Under clause 5, the liability to pay depends on the loss actual constructive of the vessel. That liability accrues at once when the casualty happens, even if the exact position is not ascertained till later. If the insured has rightly given notice of abandonment of the ship, the loss dates back retrospectively to the date of the casualty. The property then passes. And my learned friend said that Robertson did not support our submission as to the retrospective dating back to the casualty. He may have a point about the wording, but in my submission it does. And
Where was that passage you just read from?
387 of the report, 738 of the bundle, starting just to the left of the words Lord Wright in the right-hand column.
Thank you.
And this is, of course, picked up in Arnold's 15th edition. Perhaps I can give you the reference there. Arnold 15, paragraph 1118, i.e. 1118, A2, tab 41, page 1265. And
Sorry, could you give the reference again?
A2, tab 41, page 1265. And that is one of the reasons that they say there, Lord Chorley and Mr. Baylash say that Hall and Hayman can't be right and pre-NOA salvage costs must count. I may show you, Dear Lordship, that later. Anyway, Lord Porter starts at 388.
Just before we leave that, just 738, I see, dealing with clause 5, it says about 15 lines from the foot. In one sense, every case of a constructive total loss based on the cost of repairs implies that it will take some time to make the repairs or recover possession. And he goes on to say, 6 lines from the foot, the loss occurs eo instanti, and does so nonetheless because the ship owner has retained and repaired the vessel. Yeah.
I'm grateful. And if you ask yourself, what, although there's a CTL eo instanti, and the loss relates back, even though the election may be made later, when you ask yourself, what might the reason be that if the owner retains the ship and repairs it, as in this case, he hasn't got a CTL claim? The answer is he has elected under 61 to treat it as partial, not total. And we'll come to the American cases, which are merely illustrations of that principle. Anyway, Lord Porter at 739, and he perhaps I can take this. Lord Porter starts at 739, and perhaps I can draw your attention to page 742 of the bundle, 391, in the middle, dealing with the freight claim under clause 5. So in the middle, he's dealing with the clause 5 claim, i.e. is there a CTL. Having regard to the facts and figures agreed upon by the parties, the repairs required would have cost more than the agreed value of the ship inserted in the policies. Now, this was a case where, in fact, they did, because the owner did them. So that illustrates another point, which is that the would is not looking forward. The would is, at the date of the casualty, would they, hypothetically, cost more? Inconsistent with my learned friend's reliance on the would. Is this enough? The appellant says no. In his contention, there can be no constructive total loss unless the ship be abandoned to the underwriters, and he rejects that submission over the next pages. I won't read it all out. But at 743, in my submission, he makes good the submission I have just made, and the submission I made a bit earlier. But even if abandonment be not a condition of a constructive total loss, it is said that in this case there has neither been an abandonment or notice of abandonment, and the ship has in fact been repaired. So, i.e. not a CTL. In that case, it is argued under sections 61 and 62, the loss can be only treated as a partial loss. And consequently, there can be no constructive total loss within the meaning of clause 5. Section 61 no doubt gives an assured an election, but in terms, section 61 contemplates the existence of a constructive total loss even where the loss is treated as partial. It was not contended before us that there could not be a constructive total loss where no notice of abandonment was given. It was admitted that the notice was merely a condition precedent to recovery. And then this is the principle. 4 lines further down, a constructive total loss may exist, but if the assured wishes to take advantage of this, he must give notice of abandonment at any rate where there would be any possibility of benefit. If he does give notice and they accept the abandonment, the property insured thereby becomes property of the underwriters. And then this, if this view be sound, there was a constructive total loss. Now, obviously, the ship had been repaired. So the relevant date for assessing the cost of repairs, date of the casualty we submit, even though you asked the question later. And 745 and 746, may I then invite your Lordship to see what was said by Lord Porter about Rora and Forgas, which is something I'll come to. At 745, he says, this is sufficient to dispose of the case. So that's a sign that what I'm about to rely on is obiter, but nevertheless, sensible obiter. And the question is whether the loss of freight in such a case is caused by the constructive total loss of the ship. And he says, some support is lent to this suggestion by the decision in Rora, a case of freight insurance in which a vessel, though originally lost by capture, was afterwards restored to her owners, so that in one sense it might be said that the loss of freight was due to the loss of time and not to the constructive total loss. Yet Mr. Justice Roche held, and I think rightly, that one must regard the ship as having been lost as soon as it became unlikely that the owners would recover her. She was in fact uninsured and no question of abandonment arose, but had she been insured and notice of abandonment given but not accepted, the right to recover upon the hull policy would have precluded, not because she was not a constructive total loss, but because she had been restored and the owners who had been indemnified by the restoration could not claim to be indemnified over again. So the hypothetical there is on a hull policy where there has been restoration, she is still a CTL, it's just that the double indemnity rule bars your claim. And as I will submit a little later on, perhaps tomorrow, that is and is only the rule that the vessel must be a CTL at the date of NOA / date of writ. The rule really is you must not have already been indemnified. And that's for future. I'll come, as I say, I'll come back to that. So the question is...
It's quite a strong case, Rura, because there was nothing wrong with the ship. It had simply been captured by a German warship during the First World War, and it was, the circumstances were such it was very unlikely to be recovered.
Yep.
Therefore, constructive total loss.
Yep.
And in the event it actually is recovered,
Yep.
but it's still a constructive total loss.
Yep. And the only rule is, however, you can't claim for that because you'd be double indemnity.
Yeah. Double
indemnity. And I'll come forward to that. Anyway, so these are points made. These are points made. Can I just give you the references? Lord Donaldson made. Actually, that may be a good place to go. These are points made, or my points are supported in my submission by Arnold, 15th edition. I've already given you that reference. Arnold 15, para 1118. Authorities 2, tab 41, page 1265. But also convincingly by Lord Justice Donaldson, and perhaps I can finish for today by looking at what he says about this in tab 65 of Bundle Authorities 2. I'll be coming back to that. I'll be coming back to this, but for present purposes, can I invite you to look at page 1428, where he is dealing with the true nature of the rule, if it be a rule, that the facts must justify the NOA at the date of the NOA and writ, which is a different version of the same rule. Timing of the issue of the writ, and then he says, not only must notice of abandonment...
Sorry, where are you reading?
I'm sorry, page 1428 of the bundle, and it's internal page 12.
Top of the page, thank you.
Yeah, internal page 12 at the top. Timing of the issue of the writ. Not only must notice of abandonment be given after a constructive total loss situation has arisen and before the expiration of the appropriate time, so you've got to get your timing right, but there are dangers in postponing it to the writ. These arise from the common law doctrine of redemption of loss, which, although not mentioned in the Act, is probably preserved by section 91(2) as being not inconsistent with the express provisions of the Act. And then he says, I'll come to Blair more tomorrow, but he says, lest any of you don't know or have forgotten, and then he refers to Blair more, and he refers to Mr. Justice Roche in Rora, and it's in consequence of the operation of this doctrine that it's sometimes said that the validity of a claim for constructive total loss is to be judged at the date of the writ. Not correct. There's a double test, 2 dates of judgment. The first is when notice is given, neither too early nor too late, and may be justified on the facts existing at the time when it's given. However, the notice must be justifiable on the facts at the date when the writ is issued or deemed to have been issued. But the principle as he describes it, when one goes up to Roche in Rora and Forgas and Townsend, is that the true view, in my judgment, is that restoration precludes recovery, not because there was never a constructive total loss, but because an assured cannot, under contract indemnity, although he may at one time have suffered a loss, recover in respect of such loss if before action it has already been made good to him. and perhaps my learned friend, I think, has asked you to read the bottom of 1428 and 1429. And there's that point. And perhaps there are other points, but perhaps I can come back to RORA itself and futurity tomorrow.
Yes. Thank you very much, Mr. Berry. We'll adjourn, though, for the day. Thank you.